Cary, welcome back. Today we are going to talk about crisis planning, and in particular when dementia strikes a parent. So adult children that might be dealing with that are going to get some help during this episode. So when a family calls you, maybe like the week after a parent has been diagnosed with Alzheimer's or dementia, um, what does that first conversation usually sound like?
Well, what I try to do is because there's a lot of fear. They're scared, obviously, about the diagnosis. They're really concerned about the finances. So that first conversation is really about just kind of minimizing that fear and just conveying a message of this can be dealt with. We just kind of really have to go through a process. And so it's just try to eliminate all the things that they'd heard from friends and family, maybe members in other states. There's a lot of misinformation out there, even here in Florida. So they may have heard something from a neighbor that's just absolutely not true. So it's really about just trying to set the level of expectation, calm them down, and give them a sense of, this can be managed.
Mm. And some families might freeze in that moment. They don't know what might be legal advice. You talked about misinformation or medical advice that's out there, and what is just their own panic. What do you focus on telling them that they need to do first?
Well, first is not panic
Yeah.
because everything, we can deal with. Just different paths that we take depending on the circumstances. Second is I really like to get them into the office relatively quickly to deal with or to meet with my either my Medicaid paralegal or our associate attorney come in within a couple of days for an intake meeting so that there can be a good exchange of information about what they're dealing with, what the finances look like. We can convey kind of what the process is, the different programs that exist. And it really gives us an opportunity to triage the situation and determine, okay, how critical is this? How time sensitive? What do we need to kind of jump on first at that time once I get more of that information?
You mentioned determining their capacity. How do you evaluate whether they have the capacity to do it?
It's going to depend, on every situation. Obviously, I'm not a doctor, but I do have an ethical requirement to ensure that any client that I'm meeting with and I'm asking them to sign legal documents, I have to make sure that I am comfortable. My law license is on the line. I have to make sure that they understand what they're signing. And so I obviously am going to meet with them alone, so separate from those family members or friends that might have brought them to the appointment, because what I'll typically find is if I have somebody in the room and I'm asking my client questions, that person that might be with them, a child or a friend, is going to jump in. If they see any hesitation by my client, thinking of what the answer is going to be, they'll jump in and try to answer. And I know that they're trying to be helpful, but in that situation, I'll say, look, I'm going to need to have you step out of the room if I'm feeling like there's any question so that I can ask them questions directly because I need their responses in order for me to best determine whether they're able to sign something. And so I'm asking them general questions when they're on their own about themselves. And, I have their intake that gives me some information. So I'm asking about their family, their children, grandchildren. I'm asking about their finances. So I'm looking to get, the answers that are reasonable coming back. I don't expect for my clients, to understand when I'm going through legal documents, every single word of it. I want them to understand the basic concept, what the document does, who they're naming, the authority that they're conveying. So I need that general understanding. And if I'm a little bit hesitant, like, oh, I don't know, I'm on the fence about this one, I'll say, look, I don't feel comfortable unless you can get a letter from your medical provider that says that they believe that you're still able to understand these kinds of documents. So I'll kind of use that as a backup if I'm just not sure.
Mhm. You just mentioned consulting their medical professional.
Mhm.
Um, it sounds like there's a window of opportunity here, and what does that actually look like in practice? Are we talking weeks, months, sometimes longer? And like, is it that medical professional that ultimately determines when that window closes?
Well, I think ultimately it's gonna be the attorney that determines when that closes because, again, for me in my practice, I don't want my client signing things that they don't understand. I mean, from an ethical standpoint, that's a big deal. So, from the standpoint of when that opportunity closes, I mean, I always tell people, look, anytime you have a diagnosis, we want those documents, you need to get those in place as quickly as possible, because we don't know when that window is going to close. And honestly, we don't know that for anybody,
Mhm.
regardless of whether you've had a diagnosis or not. You need to have those documents in place so that you can choose who you want to make decisions for you financially and medically. You want to have those in place. And then that sets us up long term if there is that kind of diagnosis where we really need to do some planning. So every client is different, their situation is different. And I just have to use my best judgment at that moment as to whether I believe that, yes, they understand this or no, they don't. And sometimes we've had situations where I've, gone out to the hospital to have them sign something or the nursing home, and I just don't feel comfortable. And I let the children or whoever the individual is I'm kind of working through to say, look, I will try this. I will try to go out there, but I am not going to guarantee that I'm going to get these signed. And sometimes we've gone out and I say, I can't do it. Let's let that person stabilize. Maybe they've been suffering from some kind of a urinary tract infection where it's affected their cognitive abilities or exacerbated the issues. Let's give them some chance to recover and then I'll try it again. But I never give that definitive, yes, I'm going to do this. I just have to use my best judgment. And sometimes I say I can't do it.
Talk a little bit more about the healthcare directives, healthcare surrogate, and the living will, and what each of those actually let a family do once it's in place.
So in our office, when we do our healthcare documents, we're first going to be doing a living will. A living will is going to state my intentions as to my end of life decisions, right? So that living will comes into effect or becomes relevant when I've met three criteria. Number one, I'm incapacitated, so I can't make my medical decisions any longer. Number two, I have been diagnosed with either a terminal condition or an end stage condition, or I'm in a persistent vegetative state. And then the third criteria is that at least two doctors have determined there's no reasonable medical probability of my recovery. If I've met all three of those, I've signed my living will. And what it says is, look, if I've met these criteria, please do not hook me up to machines or give me any kind of procedures or things that would just artificially prolong the natural process of dying. In other words, I would like palliative care. I want, medication to treat pain, things of that nature, but I don't want anything beyond that. So, first and foremost is a living will, assuming somebody wants to sign that. Two, is we usually do a designation of healthcare surrogate. So, I'm out driving around on all these crazy streets and I'm in a car accident and I am unable to make my own healthcare decisions, even for a period of time, right? So I've named, my husband as my healthcare surrogate to essentially step into my shoes and make my healthcare decisions for me as though I was making those, right? So consenting to treatment, admitting me to the hospital, those sorts of things. And then the third one we always do is just your HIPAA. It's the release of your protected health information to whomever you want, so that there can be a free exchange of information between those individuals you've listed and any kind of medical personnel.
If someone is listening to this right now, their parent was just diagnosed, they don't know where to start. What's the very first phone call they should make?
Well, certainly you want to contact a reputable elder law attorney. I hope it's us. But our process would include having an intake meeting that could be scheduled within a day or two with either our longtime Medicaid paralegal or our associate attorney so that we can have an understanding of what the situation is and determine, what the immediate needs are of the family.
Mhm. And if a family doesn't even know, like they're overwhelmed, they're a little scared, like you mentioned, they're panicking, they don't even know if this is a legal problem yet, what would you say to them directly?
There's nothing to be scared of. It's just a matter of, I think, educating yourself, getting the good information and the correct information so that you can navigate things in the best way possible as you move forward. And yeah, this, I always tell people, we want to have the good documents in place to kind of navigate, those waters as it comes with us. I mean, everything is very fluid, right? We have ups and downs, and we just want to be able to kind of step in and solve those as we need to. So nothing to be scared of. In fact, we're very lucky that we're here in Florida. There is a lot of opportunity. And it's really just getting the good information and educating yourself.